and you agree that there are no reserves, why are you expropriating it and again promising miners that you? So it means that you know there are reserves there, and there's actual data before the commission for them to examine whether truly there are reserves or not. Because before you grant a mining lease and the various extensions that have been granted in the past, there are reserve data, year on year updated by the company. You can go back to that data and compare with the extracted resource to see whether the company has exhausted the reserves that they have declared over the years. There are no numbers to this kind of conversation, except the bully tactics to actually expropriate the mine. So that is why we are worried that the way we are going, if we are not careful, that could also turn out to be a problem for us going forward. The forensic audit is the commission itself that told the companies when they rejected the application that they were sending auditors to come and audit them. If that action is in our interest, why have you not done it and you are sacking the company? So assuming you sack the company today and you realize later that they owe us 1 billion, where are you going to take it from? Because once you sack them from that field, the company can fold up. That subsidiary, even though Anglo Gold will continue operating here, if the subsidiary falls, if the subsidiary falls, where are you going to take the money from? Right? So we are not approaching this matter in accordance with the law, in accordance with the laid down regulations. And we want the commission to go back to the law and go back to the regulation and not what they feel they can do or wants to do. And sometimes under the cover of protecting public interest are pregnant with individual and personal interests. And that's what we have seen in many of these transactions that we have dealt with. We have experience to detect when greed and corruption are at play. That we don't doubt that. And these are clear symptoms that when you cannot explain the position of the law on these matters, it is often corruption and greed that drives those decisions. That when a mine is due for renewal, the company is due for it. It's the operative word there is shall. The government shall renew the lease unless there are fundamental breaches that are also listed in the law, i.e. if they owe or there is an environmental disaster that they are not responding to. Those requirements are prescribed in law. They do not include reserve estimation. All right? They do not include some of the reasons that have been adduced by the minister to justify why they are expropriating the assets of the company. So we are cautioning that we should go back to the negotiation table and put the national interest above any other interest and make sure that the right things are done. That helps us to send the right signal to investors. If we are tired of the investors, let's tell them that we own the assets, we are tired of you. Give us our resources and go so that we can mine it ourselves. That is also an option. But let's not recalibrate and misinterpret the laws just to justify an agenda that is set in motion. For you to have remedies in your law, that says that if you make an application and there's an error, these are the processes to even remedy the error, and you are not made entitled to that remedy. It clearly tells you that the agenda is in motion and you can't stop it. That cannot be in the interest of our country. So we are insisting that we should recalibrate the assumptions around national interest so that we are not misplacing it with any other interest in this particular instance. And that is what message we want to set out today. Unfortunately, this is the only day we have until the said expropriation happens, post tomorrow. So we need government to act now and act responsibly, not to endanger the collective interest of the people. Relations twisted. You will not be far from saying yes, we are not being truthful to the law, being truthful to the requirements of statutes that govern the mineral sector. And I indicated clearly that even where there are errors, there are remedies in the law, but nobody wants to pay attention to the remedies. They are set in their minds and hearts that this is what we want to do, and we must achieve it at all costs. And that for me cannot be in the public interest. The public interest is to make sure that once gold is produced, the due interest of the state is protected. We get our share. And we must regulate to ensure that the gold is produced in the rightful manner. Not expropriation that is not consistent with the laws that we have actually set for ourselves. Risk of judgment debt. We don't want to preempt the decision of a court, but we want government to follow the rules. And as I cited numerous examples of how we have intervened in the past, where government were able to, with your support, compel government to change course, we save billions. Where government did not listen and bulldoze his way to go to court, they lost, and we are still paying billions, to us, to companies who won in court. So that possibility exists, but it's up to the court to really determine. And that's why we want the minister and the Minerals Commission to follow the law. What the law says, what is the law requiring of the decision maker to do? Let's not create new laws. And it appears in this situation that it is the hearts and minds of the interpreters of the law that is in action, and not the law itself. And that is really problematic from where we sit. And we need government to pay attention. We can keep exploring. But of course, if government is saying that you want to take up a mine, does the government have a company that is qualified to mine? It's a legitimate question that we should be asking the government. The government doesn't own a mining company. You are taking over a mine, and you are not telling the good people of Ghana how you are going to produce from the mine. And also the inconsistencies of government saying that there are no reserves in the mine. If there are no reserves, why the rush to go and take it? So you are promising the workers 0% of zero, 5% of zero. Yeah. Is that what they are promising? If there are no reserves to mine, and you agree that there are no reserves, why are you expropriating it and again promising miners that you... So it means that you know there are reserves there. And there's actual data before the commission for them to examine whether truly there are reserves or not. Because before you grant a mining lease, and the various extensions that have been granted in the past, there are reserve data, year on year updated by the company. You can go back to that data and compare with the extracted resource to see whether the company has exhausted the reserves that they have declared over the years. There are no numbers to this kind of conversation, except the bully tactics to actually expropriate the mine. So that is why we are worried that the way we are going, if we are not careful, that could also turn out to be a problem for us going forward. The forensic audit is the commission itself that told the companies when they rejected the application that they were sending auditors to come and audit them. If that action is in our interest, why have you not done it and you are sacking the company? So assuming you sack the company today and you realize later that they owe us 1 billion, where are you going to take it from? Because once you sack them from that field, the company can fold up. That subsidiary, even though Anglo Gold will continue operating here, if the subsidiary falls, if the subsidiary falls, where are you going to take the money from? Right? So we are not approaching this matter in accordance with the law, in accordance with the laid down regulations. And we want the commission to go back to the law and go back to the regulation and not what they feel they can do or wants to do. And sometimes under the cover of protecting public interest are pregnant with individual and personal interests. And that's what we have seen in many of these transactions that we have dealt with. We have experience to detect when greed and corruption are at play. That we don't doubt that. And these are clear symptoms that when you cannot explain the position of the law on these matters, it is often corruption and greed that drives those decisions. The government decision, based on the advice of the Minerals Commission, not to renew the mining lease of Abosu Goldfield Limited in Daman. In the course of this week, acep has closely monitored this development. In the interest of public accountability and the integrity of natural resource governance, acep sought to engage key stakeholders to ensure that the government decisions followed due process and adequately mitigated risks to the state. As part of this effort, we held discussions with government officials, on Monday, and on Tuesday, we engaged the company and the chamber. And in that process, also reviewed the legal documentations around renewal of mining leases. Though these engagements were informal, driven by our sense of urgency, it was encouraging to witness the openness of the public officials to share their perspectives. However, we had hoped that the communications between the government and the company will be maintained for a little longer to explore a possible compromise, whether that meant facilitating the company's exit or supporting its continued operation. Now, I'll take that again. Though these engagements were informal and driven by our sense of urgency, it was encouraging to witness the openness of public officials to share their perspective, and as well as the companies to engage with us on this important matter. We had hoped, however, that the communication lines between the government and the company will be maintained for a little longer to explore a possible compromise, whether it meant facilitating the exit of the company or supporting its continuous operation. As a responsible policy think tank, acep has seen similar cases where public officials were convinced that their decisions were in the interest of the state, but were proven to be wrong. Consequently, those decisions have escalated into costly outcomes for the state. And I'll cite a few examples of that. And we have engaged you on multiple occasions on some of these matters. The attempted novation of the Ameri power plant, which possibly would have cost this country about $850 million. The Ajapa royalty transaction, which would have ceded Ghana's royalty stake to private interest, which today has raised over $1 billion, though we're looking for $500 million. The GMPC's attempted acquisition of Aker Energy assets for $1.65 billion, which turned out to be sold few years after for $1. We had to intervene to make sure those things did not happen. You also remember the recent forced attempted unitization of the ENI Springfield oil blocks, which went to arbitration and we lost. There are countless number of that situations, those situations that we have had to intervene as civil society. The advocacy on these matters gives us and our colleagues in civil society a solid track record of dispassionately analyzing government decisions, especially when they are made in haste and we can see that they are on collision course. These are not vindications we celebrate when they happen, but we continue to mourn for the losses to the state and the continued decline of investor confidence in the resource sector. We are therefore compelled to speak out to help reopen the lines of communication and encourage an amicable resolution grounded in our laws and sound industry practices. Ghana has been bruised too often by hasty decisions, and we must remain vigilant when such risks become apparent. By examining the laws and the information before us, we know that the state's decision, that the decision of the government to take over the mine after April 18th, which is tomorrow, 2025, is premature. That's our conclusion. Particularly given that the basis for the lease rejection in itself is being contested. The law is unambiguous in this matter, Section 27 of the Minerals and Mining Act 2006, Act 703, as amended, states, and I will quote expressly, subsection 1 says that where a dispute arises between a holder of a mineral right and the Republic, all efforts shall be made through mutual discussions and, if agreed, through alternative dispute resolution procedures to reach an amicable solution or settlement. Subsection 5 also states that where a holder has notified the minister in writing that the holder wishes to refer a dispute for resolution, but for this subsection the terms of the mineral right would expire, the term shall continue without diminution for the period ending 30 days after the determination of the dispute. And I explained that. What this provision is saying is that when the company indicates its right to seek for redress in court, the government shall stay its action until that dispute is resolved before further actions could be taken. That is not what we are seeing. We understand that the company has formally notified the government of its intentions to seek redress through arbitration, as is their right, and there is also the responsibility of the state to respect same under the mining lease. That notice satisfies the condition under section 27(5), as I read, and accordingly, the mine's operations should remain undisturbed until the dispute is resolved. And now I want to go through some of the reasons that have been cited by government. And the primary reason cited for the rejection of the lease application, the public deserves a more rigorous and objective explanation from the government, because we don't see that. The suspension of active mining must comply with Regulation 22 of the Minerals and Mining General Regulation 2012, LI 2173. Subsection 1 reads, subject to Section 51 of the Act, where the holder of a mining lease proposes to suspend, discontinue mining operations, the holder shall cause to be prepared for the satisfaction of the Commission an accurate plan of the mining operation as at the time of discontinuance or suspension, and shall subject that plan to the Commission in accordance with these regulations before the mining operations are discontinued or suspended. The April 16, 2025 statement from the Minister of Lands and Natural Resources indicated that the company had stopped active mining and was merely processing stockpiles. However, they do not prove how processing stockpiles breaches the mining lease or the law, particularly when there are remedies in law for the suspension and discontinuation of a mining operation. Stockpiles are materials already mined and stored for future processing. Depending on the grade of the stockpile, the economics of the project may define when a particular grade is processed. The production of 135,000 ounces of gold from these stockpiles in 2024 underscores the value and the relevance of the stockpile to the mine's output. The company has indicated that they communicated and obtained approval from the Commission to process the stockpile. The Minister ought to verify this claim with the Commission in alignment with provisions in the law before drawing conclusions. If the company's claim is true, then the regulator cannot turn around to use the same operations as a basis for rejecting the renewal of the lease. If the claim is false, then the regulator, through its Mining Inspectorate Division, has failed to enforce the law and cannot use the failure as a tool for punishment. There are further reasons that I want to talk about, cited by the minister for the rejection of the extension, which requires scrutiny. One, the minister said there was failure to declare mineral reserves. While there is no basis in law that not exploring for 2 years out of 30 years of operations is a basis of invalidating all the existing reserve data that shows mineable and contingent resources, the company indicates that it has conducted exploration and pre-feasibility studies and submitted technical reports indicating mineable resources with an 8-year production outlook. These claims deserve independent verification rather than dismissal. And let us note this: if the basis of the termination has been communicated by government is on account of no reserves in the mine, and the states assume that indeed there are no reserves in the mine, then it is confusing why the state is so eager to assume the risk of operating a mine that has no reserves. The second point that the minister uses is that there was an absence of a technical program. The company maintains that it submitted a technical program consistent with its previous renewals, because it has done previous renewals and the template is there. So he submitted the same renewal consistent with this previous renewals. This requires that the minister publishes the documents to clarify the facts and reassures the public that is really fighting for the interests of the people. Another claim is that there was lack of budgetary allocation for exploration. That also is a matter in contention. The company has indicated that it continued to carry out exploration-related activities known to the commission and claims to have receipts and reports before the commission confirming this situation. These two require verification before any definitive conclusions are drawn. But ladies and gentlemen, most importantly, Section 191 of the Minerals and Mining Licensing Regulation states, and I read, where an application does not comply with Sub-Regulation 1, the Mineral Title Department of the Commission shall give notice accordingly to the applicant within 5 days after the review, and set out in Form 3 of the first schedule, and the applicant, in this case the company, shall correct the errors or provide the information required within 10 days from the date of the notice. So what it's saying is that when you put in a renewal application and there are errors in that application, you are allowed 10 days to remedy those errors in the application. We require that the minister verifies whether this standard process was followed before allowing a decision of this magnitude to proceed from the commission. Again, assuming government is right on this decision, it is also important to note that any mine closure must follow well-defined protocols. Assuming you want to even take over the mine and operate it, the company has responsibility to the state. The company is required by law to submit detailed exit plan for remediation, environmental governance, and fulfillment of outstanding obligations to the state and contractors. These provisions appears to have been overlooked in the haste to take over the operations of the company. although the Commission's lease rejection letter audit will begin within 14 days of notifying the company, it has been more than a month, and there is no indication that the audit has commenced. If this process is truly in the public interest, that is to audit the company to make sure that they have not cheated the state, why did the Commission renege on this important responsibility and proceeded to expropriate the mine? Such inconsistency must be addressed and require answers from government on them. But I also want to point out the most significant undercurrent on this whole development. Industry enthusiasts like us may be aware that in recent years, the company has been exploring options including a divestiture of the diamond mine, as it indicated in its 2024 report that the reserve does not meet its conservative mineral reserve economic criteria, which does not mean that there is no gold reserve in the mine, as is being interpreted. The conservative economic criteria is just a decision tool which tends to be dynamic based on changing economic variables around the operations of the mine. The state and its agencies cannot pretend not to understand this economic decision tool in the industry. To the extent that the Commission is holding such a dynamic tool constant and impede any change in the company's position, even as the economic variables change, is regrettable. I conclude on this subject by saying that acep agrees that Ghana deserves to benefit fully from its mining mineral resources. However, any stakeholder truly aligned with this national goal must be transparent and factual in demonstrating how their decision maximizes public benefits. The government's approach to this matter should reflect diligence, legal compliance, and a genuine commitment to long-term mineral wealth of our country. A rushed and disputed decision not only risks international litigation and reputational damage, but also undermines investor confidence and the rule of law. Already, the news portals have captured state officials, and also as implied in the minister's statement, that this is all an effort to nationalize the mine. If the policy direction of the government is to revisit the 1970s resource nationalization effort, which collapsed the mining industry until we revisited investment drive, we need clarity from the government on what will be different this time, to leave no doubt in the minds of the investors, especially when the required actions per the law are clear, but actions of implementers differ. Ladies and gentlemen, when remedies are provided in the law, the hearts and minds of the implementers cannot be at variance with the prescribed remedies in the law. And we want government to note that. acep costs were halted in the operations to expropriate the mine tomorrow, and the indication that tomorrow is not only Christ that will be crucified, but the mining industry risks crucifixion as well. The government needs to exercise restraint, renew dialogue, and pursue a legally guided resolution that protects the interests of both the states and the investors. I thank you for your attention.
Thanks for watching. Please like, subscribe,
and click on the bell for more updates.